In this lesson, we'll discuss how to maintain your Georgia real estate license, which can be found in the Georgia Real Estate Commission Rule 521.05. Let's begin with the required education for salespersons in order to maintain their license. The Official Code of Georgia Annotated, or AGA, consists of all the laws in Georgia. The AGA Section 4348D says that every salesperson has to provide the Commission with evidence that they completed a 25-hour post-license course within 1 year of obtaining their license. Salespersons have to complete their course within 1 year unless they qualify for a 6-month extension. For example, salesperson Iris Miller is a new salesperson who is called out of the country to care for a sick relative. She asks for a 6-month extension, which is approved. In this case, Iris has to complete her 25-hour post-license course within 18 months of receiving her license. Sometimes a non-resident salesperson has completed a post-license course similar to Georgia's. As long as the course was completed prior to receiving a Georgia license, the salesperson doesn't have to take the Georgia post-license course. For example, Hans Rosenstein moved from Florida, where he was a sales agent, to Georgia. Hans completed his post-license course in Florida, a state considered similar to Georgia in terms of real estate law. Hans doesn't have to take the post-license course in Georgia. To renew an active license, a salesperson must finish 36 hours of continuing education during the renewal period. Licensees have to complete 3 hours of continuing education covering license law within every renewal period. Next, we will talk about the difference between active and inactive licenses. Salespersons in Georgia may have an inactive or active license. This section explores the difference between the two. We are starting with the requirements for an active Georgia salesperson, associate broker or community association manager. These licensees must be active under a Georgia broker. An active Georgia licensee can also affiliate a license with a broker out of state if all of the following conditions are met. 1. The other state's laws allow dual licensing, and 2. The Georgia licensee has the written permission of their Georgia broker to affiliate with a broker from another state. For example, Forrest Ellison just got a license in Georgia and wants to keep his Florida license active as well. However, Florida doesn't allow dual licensing. Therefore, Forrest cannot have a license in both states. A salesperson can begin the activities of real estate until their broker receives their wall hanging. The same holds true if the salesperson is active under a limited liability company, partnership, corporation or sole proprietorship. A change application to the Commission is required before a licensee begins to work under another broker or as a qualified broker themselves. Salespeople who wish to activate a license on inactive status must complete the continuing education requirements that would have been due if they remained active, unless they have already done so. Alternately, they can also requalify as a new applicant. Inactive licensees can practice as a real estate broker, associate broker, salesperson, or community association manager. This includes leasing, sales, property management services, community association management services and any other brokerage activity. An inactive licensee can perform real estate activities for an unlicensed person who owns the property. To reinstate their license, they must reapply as a new applicant. For example, Jolie Harper is a licensed real estate agent in a Georgia brokerage. She is offered a job selling condos for the unlicensed owner-developer. Jolie must inactivate her license and will have to reapply if she decides to practice as a salesperson under a brokerage again. Next, let's cover how renewals work for Georgia real estate salespeople. If renewal fees aren't paid, all licenses will lapse. For an individual, that's the last day of their birth month. For a firm acting as a broker, the deadline is the last day of the month 4 years after the original license was issued. How do you reinstate a lapsed license? Any licensee whose license lapsed for failure to complete education requirements and pay the required fees can get their license reinstated. The conditions include simply paying the appropriate fee and completing the required continuing education. A salesperson who doesn't pay a renewal fee and lets their license becomes inactive can reactivate their license within 2 years of the date the license lapsed. Any lapse longer than 2 years and under 5 years can be reinstated by paying back fees and taking the appropriate class. These classes include: for community association managers, the Community Association Managers per License course. For a salesperson, the Salespersons per License course, and for brokers or associate brokers, the Brokers per License course. These courses have to be taken within 1 year. For example, Adam Jones is a broker who let his license lapse 3 years ago. He must pay the renewal fee and take the Brokers per License course within a year of the time he pays the renewal fee. Any licensee who doesn't pay a renewal fee can also retake and pass the appropriate exam for that license, including the national portion. Any license that lapsed for more than 5 years requires that the applicant requalify as an original applicant. If you don't take the 25-hour post-license course and let your license lapse, you have to reapply as an original applicant. For example, Maeve O'Donnell doesn't take the post-licensing course within 1 year of receiving her license. She then lets her license lapse for more than 5 years, at which time she needs to reapply as an original applicant. Next, we will address the rules behind notification of legal action or change of address. You must notify the Commission in writing if you get a final disposition from a court decision or administrative board ruling. The notice of civil or administrative rulings is due to the Commission within 10 days and should include a copy of any final order by the agency or court. The same applies to any conviction and must include a copy of the accusation, indictment or conviction. For example, Donna Yap is a salesperson in Atlanta. A client has filed a case against her in a civil court action. Fortunately, the final disposition is in Donna's favor. Even still, she must send a written notice to the Commission within 30 days of the judgment. Each approved school, licensee or approved instructor must notify the Commission within 1 month of a change in mailing address or residence. The same goes for a change of email address, if applicable. For example, Prince Stover moves his Athens brokerage to a location with more foot traffic. He must notify the Commission within 30 days of his new address. Now, let's take a look at the rules surrounding non-resident licensure and brokerages. Non-resident licensees must decide whether to stay active or become inactive. There may be additional administrative steps, which we will discuss next. Non-residents who meet all the requirements by the OCGA Section 4349 and the Commission can obtain a non-resident license. Licensees who move to another state may qualify for non-resident licensure if they request a change in status from resident to non-resident. They must also sign a consent to jurisdiction and agree in writing to cooperate if the Commission initiates an investigation. A non-resident broker may be the qualifying broker for a limited liability company, corporation or partnership. They can also be the qualifying broker for an out-of-state limited liability company or corporation licensed by the Commission and acknowledged by the Corporation Division of the Secretary of State. For example, Giselle Alvarez lives in Florida and is a Georgia non-resident broker. She can act as the qualifying broker for Best Brokerage, a corporation, in Savannah. Georgia licensees who move out of state can place their licenses on inactive status if they don't want to become a non-resident license. This prevents termination of their license. Licensees with an inactive status can't conduct brokerage business until they become Georgia residents and comply with the appropriate reactivation provisions of OCGA Section 434012. Any non-resident licensee who doesn't pay their renewal as an applicant can reactivate their license as long as they kept an active license in their own state of residence, and they complete the Georgia continuing education requirements. Georgia licensees are restricted to performing real estate services within the state. The only exceptions are those with a valid license in another state. For example, Virginia Bell is a non-resident Georgia broker. She is not licensed in another jurisdiction and can therefore only perform real estate services in Georgia. Our final topic in this lesson is how you can keep your WAL certificate and wallet card upon your retirement. If you retire after 20 years of actively using your license, you can keep your WAL certificate.